Hi there. My name is Hans Schenk. I'm a professor at Utrecht University, and I'm one of the people involved with teaching for a number of years already a number of courses in the domain of economics, law and finance. One of the courses that we teach under the umbrella of the Utrecht University Summer School is corporate governance after the financial crisis. That contains two elements: corporate governance on the one hand and the financial crisis on the other hand. And you may wonder what these two have to do with each other. Well, that is basically the insights that we are trying to convey to you when taking part in this course. Let me first refresh your mind in recalling what corporate governance is. And in order to prevent any misunderstandings, let me read this from a paper so that we have no problems in interpreting what we are talking about. Corporate governance is a system by which companies themselves are directed, monitored and controlled beyond the supervision of public authorities like competition authorities, stock market regulators and what have you. So corporate governance involves the firm in the inside. It determines whether we, for example, opt for a one-tier governance system. A one-tier governance system implying that outsiders and insiders collectively sit in one board. Whereas more common in the Netherlands, for example, is a two-tier system in which the outsiders, the supervisors, are separated from the executive board or the management board. They meet, of course, very frequently, but they are separate authorities. And the law, as well as the economic implications of these different structures, have been studied in the framework of corporate governance. Now, it's not just that. There is a lot more. For example, what do we do with the shareholders if your firm, or the firm that is in question, has shareholders at all? How much have they, what's their impact on decision making? Can they meet in annual shareholder meetings, and how important are these meetings? Are they circumvented by the management? Another issue is, what about co-determination? Will we have to deal with what is called in the Netherlands works councils, and across several other countries in Europe as well? Or do we have other co-determination systems, for example, representatives in the one-tier or in the two-tier board? These matters are important. Why are they important, and why have they become much more important over the last 2 or perhaps 3 decades? This has to do with the fact that, especially around the turn of the century, we have seen many developments taking place. They were in the making years and decades perhaps before, but they culminated around the turn of the century in a sudden eruption of globalization. That is to say, firms that started working across borders and met different legal jurisdictions and had to work in several different jurisdictions at the same time. Similarly, most of these firms grew in size and grew in patterns of activity also across these borders. Secondly, what we saw was that also, especially in the beginning of the current century, many large firms from Italy to the US to the Netherlands were, how should I say, were fixing their books, large scale fixing their books. And later it turned out that it was not just fixing the books, but it was a matter of what we called corporate fraud. We saw self-serving behavior by management, and ultimately what we saw in 2007-2008 was a large financial crisis that has been explained as a result of the structural changes that took place in the decade and a half that was preceding it. Now, what can we do on that? Can we do anything? You can regulate, the state can intervene, but if we're talking about corporate governance, not the state that intervenes, it's the company itself that brings in place a number of structures, a number of institutions, a number of authorities that deal and deal with these issues and make sure that these elements of corporate fraud will not so easily erupt any longer. So this is actually what we focus on. We focus on what could go wrong in firms without this impinging on outside forces, but we also look at how it can impinge, for example, on productivity, on efficiency, on shareholder value, and all sorts of other indicators of the performance of firms. Thus, in the end, what we emulate, what we try to do with this course is teach you how firm behavior can be improved in various respects. In respects of its own private individual goals, but also in terms of social goals, which means that we very quickly end up in discussions concerning corporate social responsibility, or abbreviated as CSR, in which the primary question is the behavior of the firm not just good for those that own it, but also good for society? Now, this covers approximately the issues that we discuss in the course on corporate governance, but we will adapt, of course, to actual things going on, to topical issues at the moment, and especially when we have the opportunity to prepare the courses only a few days before, we will be able to address the issues that you read in your newspaper or on screen just the day before.
Professor Hans Schenk already told you what corporate governance is really about. You don't have any corporate governance without shareholders, and no shareholders without shares. So who invented shareholder capitalism in the modern sense? That was the United East India Company, de Verenigde Oost-Indische Compagnie, established in 1602 on the basis of a charter by the States General, the highest governing body of the Republic of the Seven United Netherlands. What happened? The VOC issued shares, actually transferable receipts, and acquired a capital of 6.5 million guilders. This equity crowdfunding became the basis of the world's first stock exchange, Amsterdam AEX. And how much is this 6.5 million guilders in today's money? What do you think? Well, actually it's about $7 trillion. It's 7 times the value of Apple. What was the impact of the VOC? Well, Shorto, an American writer, wrote about this. As a snapshot, in 1625, VOC warehouses in the Netherlands contained almost 4 million pounds of pepper. The year after, thanks to especially successful voyages, there were nearly 6 million pounds of pepper packed in the little canal-side buildings of the city's middlemen, not to mention warehouse on warehouse filled with cinnamon, stockfish, tea, whale oil, sugar, salt, sailcloth, silk, beer, tobacco and other goods waiting to ship out again. And here you see an example of such a VOC ship, and here you see the canal houses built by the rich merchants of the Netherlands with the money of the VOC. Other legal highlights of this course are the lectures of Barbara Elion, a young attorney at Loyens & Loeff, who will connect the COVID crisis with modern corporate governance issues.
By way of introduction, my name is Barbara Elion and I am working at the Litigation and Risk Management Department of Loyens & Loeff. This summer I will give 2 lectures about corporate governance after the financial crisis and in the view of the current corona crisis. The first lecture will be about directors' liability in the Netherlands. In the second lecture I will focus on the rights and the position of shareholders in Dutch companies. Over the past 5 years I have advised and represented many clients about these topics, and I noticed and learned that there are many differences between our legal system and especially common law systems such as the UK or the US, but sometimes even European countries. The purpose of these lectures is to give you a better understanding of how our legal system works, but also what the differences are between the Dutch system and your own legal system. In the first lecture, I will focus about the duties of directors and the grounds for directors' liability. What are the duties of directors? How should they perform their duties? And most important, what are the grounds for directors' liability? Each country has developed its own standards and grounds for directors' liability. In the Netherlands, directors are not easily held liable. Directors have a large discretion and freedom to perform their duties, but also to determine the strategy. There are, of course, exceptions to this rule. Directors can be held liable by the company in case of improper performance of their duties. They can also be held liable by third parties, such as shareholders or creditors, on the basis of tort. For example, if a director selectively pays certain creditors, the other creditors can hold, under certain circumstances, the director liable. And another ground, which is maybe even most important in these difficult times with the coronavirus, is that directors can be held liable by a bankruptcy trustee in case of bankruptcy. Well, during the summer course, we will focus on these main director liability grounds, but we will of course also touch upon several other grounds for directors' liability. Given the uncertainties surrounding the current corona crisis, it may be difficult for directors to assess the consequences of their actions and decisions. We have many clients seeking legal advice about whether certain decisions can result in directors' liability. For example, what if a company entered into an agreement but is no longer able to fulfill the obligations under that agreement? Does that immediately result in directors' liability? Or is it something that directors should not immediately fear about? Or what happens if a company has financial difficulties? What can directors do to prevent directors' liability and mitigate risks even further? Well, these are the kind of examples that we will discuss during the summer course. We will, of course, also touch upon the recent emergency legislation from the Dutch government and recent case law. The second lecture focuses on the role and the position of shareholders in a Dutch company. Shareholders play an important role in the checks and the balances of a company. And traditionally, the division of powers between the management board, supervisory board, and the general meeting is as follows. The management board is responsible for the day-to-day business and the strategy of the company. Supervisory board supervises the management board. And the management board and the supervisory board are both accountable towards the general meeting. Well, so individual shareholders and the general meeting should in principle not interfere with the strategy. It is not uncommon that shareholders are not satisfied with the strategy or the course of affairs of the company. In that case, there are several instruments or strategies available for so-called shareholder litigation. In this lecture, we will focus on the topics and the instruments the shareholders have to actually enforce their rights or maybe sometimes even force the company in a certain direction. After the previous financial crisis, important case law has developed about the rights and the position of a shareholder in a company. We will, of course, take a look at the most important or milestone cases we have, such as ABN AMRO, ASME, and AkzoNobel, and maybe even more recent decisions. Well, these cases are of course very relevant, but I actually hope and expect that with the current corona crisis around us, that there will be maybe even new or better examples of shareholder litigation when we see each other in July. Until then, be safe.
Hello everyone. Welcome and thank you for your interest in attending the summer school program at Utrecht University. My name is Luigi Pinna. I teach economics. I've been teaching economics for 10 years at the Utrecht School of Economics, mainly business economics. And I've been involved with the summer program for the last 4 years. I'm here to share with you information about two specific courses. This one I will tell you about the economics part of corporate governance. You may have already heard some of the details about the law side of corporate governance, such as how companies are created and established. The economic side is how companies are actually run in terms of who the agents are, which are the managers of the company, and who the principals are, which are the owners of the company. And the agents are supposed to behave in a manner that they fulfill the interests of the owners. And to a lot of people that means owners are shareholders, shareholders want returns, companies got to make money. but there's a lot more involved to this in the modern corporations. And this is where things sometimes go kind of off track. You hear a lot about corporate failures, frauds, mismanagement, bankruptcies, sometimes with some very successful companies that nobody knows where this came from. This is often a problem of poor corporate governance. But what is it? It's the fact that some people make decisions with other people's money. The managers, in essence, have a lot of control about what to do with the funds obtained from other people. Generally, it works well. When it doesn't, we hear a lot about it. In this respect, and I've worked in corporate governance for many years in my professional life before I became an instructor, and I was on several boards, supervisory boards and management boards in both the United States and in European companies that we did joint ventures with. And the way companies run is, one, not very knowledgeable to a lot of people, and two, highly dependent on things that are often soft, like skill sets, personalities, a number of items that at the end of the day, you can actually determine why a company was successfully managed and why some failed. The real interesting cases we talk here are usually about corporate fraud, about how some people thought they could get away with taking all the money for themselves. Those are some of the cases we'll highlight as far as how can this have happened when so many people are involved and so many people were supposed to make sure things went right. It is quite an interesting aspect of it. I discuss the economic side of it, and which goes hand in hand with the law, so it's a very good integrated program. We hope to see you there. Thank you.